So, in what you're talking about is a little bit of what we would call judicial mediation. And so we have it in another situation, I think, that is involved with some of the allies where they've chosen an arbitrator, and the arbitrator is a former judge, and that arbitrator is going to pre-mediate before we head to arbitration. And arbitration, for all intents and purposes in the divorce world, is the same as going to trial. It's just that, it's more of a private judging situation where you might be at an office as opposed to, and they set up their office to still look like, that they're at the head of the table and everybody's kind of surrounding in these big conference rooms. But I think that this is ideal if you have, and then we have a couple of judges, because just so that you know how the judge system works, like a lot of times judges have to do a rotation in family law in order to become a judge in another area. And so sometimes that rotation could be 2 or 3 years that they have to do their time in family law before they can go. Like a lot of times they'll even think like doing traffic court is better than family law, right? So in these situations, you have judges that are going to roll out very quickly. And then you have some judges that always wanted to be in family law and they stay there, and then they have like longevity, but you can also then see like how they've, determined cases. So in a situation where you have a judge that realistically, the judges that I worked with that were more in long-term positions, they always mediated, especially if we had a complex valuation issue. They would be like, hey, in one of the settlement hearings, when we got close to trial, they would just be like, hey, let's have your experts here and we can just talk about some of these things. And so what Victoria is talking about is absolutely ideal, because that judge is going to eventually determine your case. And so then it becomes very strategic what you are talking about with them when they're mediating, because you are basically, and this is with any mediator, but specifically in this situation, you're basically getting an indication of where that judge would come if they were to try the case, which they eventually will. So what it allows the judge to do is to tell you, you know what, that position is really good, or I don't believe you. I don't believe that the business is worth nothing. They're going to pre-tell you. So it's almost like you're pre-trying the case. And if in that pre-trial or that mediation, things are not necessarily going the way that you thought it would, that's going to be more fuel to settle in some capacity. And that would be the goal. The judge can ask more questions in that more calm kind of fashion and try to get to the issues very quickly, which means you have to be methodical with your position statement. You have to be methodical with like how you bring an abridged version of what you want to present to him in the long run. So it's going to be even more important that you identify those 3 points that are very important, that you have some substantiation or evidence if there are gray areas, and that you are putting forth, like bringing the parenting plan and saying, here's what we're starting to work with. And he goes to, your spouse and says, what are the issues? So in my mind, it is more informal, but you cannot allow that informality to affect your strategy. So just because it's informal, that is definitely in your favor, but don't let up and be like, oh, you can be chummy with the judge. No, you cannot. You almost have to like maintain your credibility, your, definitely your